It's preparing, and as soon as... Okay, so we are already on. So let's begin. So today we have Hilary Nye from the University of Alberta in Canada. She's going to present us a paper about eliminativism with a long title. I just forgot it. It's "What is the is question in what is law?" Did I get it right? Yeah, eliminativism in legal philosophy. This series of seminars is jointly organized. The number is getting bigger now. The UFMG Law School, but also the Brazilian Association for Law and Philosophy, the Brazilian ABRADT, which is fiscal law, and the Serras de Minas Association is another local association of law and philosophy, and other universities and colleagues that help me do it. It's a great honor to have you here, Hilary. I will just let you speak for about 25 minutes. You will do a tough assignment of summarizing a paper of 50 pages in 25 minutes, but that's, if you want to take a few more minutes, go ahead. After you speak, I invited Ronaldo Macedo from the University of São Paulo. He prepared a few comments for you, and then we will start a session of questions and answers. Thank you very much, and I hope that we have a very nice evening for us. Okay.
Wonderful. Thank you so much. Thanks, Thomas, for inviting me. It's really a pleasure to be here. And obviously, I wish I could be visiting Brazil in person. That would be lovely. But this is the next best thing. So I'm delighted to be here. And thanks, everyone else, for joining. So as Thomas said, it's a bit of a long paper, and I apologize for that. But for that reason, I'm not going to assume that you read it. So what I'm going to do is just provide a bit of an overview of it, kind of just some of the key points to get the core idea on the table. And so that core idea really is to pose an objection to a kind of turn in legal philosophy towards approaching things from a metaphysical perspective. So I've seen this as a kind of common thread in recent legal philosophy, kind of tendency towards this metaphysical picture. And I'm arguing against that kind of methodology, the idea of seeing legal philosophy as aiming to answer questions about the very nature of law. So that's kind of what I'm arguing against. So the kind of foundational question in legal philosophy has been, what is law, right? We're trying to understand what this phenomenon is. And that question itself has been understood in a variety of different ways, but most recently, as I was just saying, it's kind of been interpreted as a metaphysical question about law's nature. So the idea here is that people argue that they can understand the law's nature and that they can do that through using the methodology of conceptual analysis. And what I argue in the paper is that that approach is a mistake. So first of all, it presupposes that we can actually discuss what the law really is, that there's some sense of what it really truly is that transcends our varied experiences of all the things we might call law, so the actions of the legislature, the executive, the judicial branch. And so this way of doing philosophy where we're trying to isolate the singular nature of law, in my view, it's not responsive to all of that evidence, all the stuff we look around and see, all of those actions of the various branches. And so I'm going to argue against that approach in legal philosophy, and I'm going to argue instead in favor of what's come to be known as eliminativism about law, which is a little bit of a mouthful, but I'll say more about what that is later on. But just to start with, what is it that theorists think that they're doing? So typically legal theorists say, or maybe don't say, but it's implied in the background of what they're doing, that the truths that they're seeking about law are not social scientific observations about judicial practices or anything else observable. Their aim is at something deeper, so the very nature of law. And they use the method of conceptual analysis to provide insight into the nature of that thing. And so one aspect of this is that it requires intuition. So there's disagreement about how to characterize intuitions, but without getting too far into the complexity of that debate, we can think of them as just beliefs about what's true and they're often sort of held before we've reflected on them. So if someone says that law has something to do with power, we might have an intuition that that is or isn't true, so we hold a kind of belief about what law is like. But the problem is that we have conflicting intuitions. So when someone says law has something to do with power, someone else might have the intuitive view that that's not right, that it doesn't reflect law's nature. And so this conflict of intuitions leads to disagreement. So disagreement is the fundamental problem here, and a big part of what I talk about in the paper. So essentially, legal philosophers disagree about what the nature of law is. And I want to be clear here that disagreement itself is not problematic. So obviously legal researchers disagree with one another all the time. So it's not disagreement per se that I object to. But what I want to try to show is that the disagreement in this particular debate in legal philosophy is characterized by certain traits that make it pervasive and impossible to overcome. So it's a particular kind of problematic disagreement that leaves us in an impasse. And so the way it arises, this impasse, is that because the process of conceptual analysis leads to different accounts of the nature of law, which are all built on intuitions about the correct application of the concept, but that foundation of intuitions is problematic because our intuitions conflict. And so therefore we end up with this impasse. So just to take very briefly the kind of classic debate about the nature of law. So we have the kind of natural law or non-positivist view that says morality is part of law, or law contains moral propositions. And then we have a positivist view that says morality cannot be part of law. Of course, this is really oversimplified, but I think we all have some understanding of these two basic views. So I'm not going to go into the nuance of all of them. But if we have sort of on one hand, the view that law is just a matter of social fact or social sources, a positivist view, and then on the other hand, the view that law is partly a matter of moral considerations go into making up what law is. So those are the kind of two views, just again, in a very simplistic kind of form, but the two views that I want to have on the table. So for the positivist view, if law is a matter of social fact, then when judges appeal to moral sources, we have to understand them as going outside the law and exercising discretion to make new law. And so the point that I want to try to make here is that the very structure of this disagreement doesn't allow for appeal to experience. So both views rely on intuitions, which determine what we say about law's nature, and those intuitions drive the view that's adopted. And so there's no example that can make a difference here. So the question can't be resolved by looking to our experiences. The theoretical standpoint that we take that's driven by our intuitions kind of takes priority, and it determines how we categorize particulars. So what the theory says is primary and kind of sets the parameters of what counts as law. And then if people disagree about those boundaries, we can have all the examples in the world, but these examples or our experiences are not going to be capable of resolving that disagreement. So in other words, there's kind of no authority we can appeal to, or nothing that can tell us whose understanding of the practice is right, or which of our intuitions we should discard as false. Because of course, if we have multiple competing intuitions, we have to determine which we would rule out or which we would discard in order to determine what the true nature of law would be. And so this is where it's really crucially different from empirical disagreements, right? So in cases where we're truly engaged in describing the world, there are facts in the world that represent the neutral data to which both myself and my interlocutor are going to be bound, right? So if our accounts fail to fit that information, they're going to fail as descriptions. So just to take a kind of silly example, if you and I have a disagreement about what flavors of ice cream are offered down at the local ice cream parlor, there's a way to resolve that disagreement, right? We can go there and see for ourselves. So we find out, do they have rum and raisin or not, right? So there's a prospect of resolution, and there's also an agreed upon method for that resolution. So we both know what would count as finding out that they do have a given flavor. But we might also have a disagreement of a different character. So if we disagree instead about whether ice cream could ever really be a meal or whether it could only be a snack or a treat, there's kind of no way to resolve this problem, right? Because I could try to bring up all the evidence that I want. Maybe I can say, look, I ate it for lunch yesterday, so clearly it was a meal. But then it's open to you to just respond, look, you might have eaten it at noon, but all that means is that you skipped lunch and then you ate a treat instead, because ice cream can never be a meal. So in other words, here we have sort of fundamentally different conceptions of what counts as a meal, and those are driving our determination of how we categorize ice cream. So it's there's nothing in the ice cream shop or anywhere else in the world that we could point to resolve that dispute. And so even though this example is a trivial one, I think the point is a serious one. So the very structure of the methodology that's employed here makes resolving disagreement impossible. So it puts intuitions about the nature of things as primary, leaving nothing that we can point towards as a counterexample, or in other words, when we raise counterexamples, those are able to be recategorized by the theory, and so counterexamples are unable to really do the work of disproving a theory. So if I provide an example that I think disproves the theory, you're able to just deny that that example really counts as an instance of the thing in question. So we can redo the ice cream example with a more law-related one, right? So in the paper, I use an example out of the California Civil Code, but we could find endless versions of this, but this is just a nice example where the morality is spelled out very cleanly. So we have a statute basically that says that is not lawful, which is 1, contrary to an express provision of law, 2, contrary to the policy of express law, though not expressly prohibited, or 3, otherwise contrary to good morals. So this is in a statute dealing with contracts, saying what contracts are or are not unlawful. And so the one I want to focus on is subsection 3, right? So it's saying contracts will be unlawful if they are otherwise contrary to good morals. So we've got morality incorporated into law there, right? So the facts on the ground are going to be clear, and they're going to be, I think, agreed upon by anyone who's honestly engaging in this dispute. So we have a statute that states that immoral contracts can't be law. All the theorists around are going to agree on the wording. They're going to agree that it's a valid statute, and they're going to agree that it directs a judge to use moral reasoning. They'll also agree that statutes are part of what's properly appealed to in figuring out the law. But despite all of that agreement, we still could end up with basically different descriptions of what that subsection really does. So for the non-positivist, it's just going to be yet another example of the intertwined nature of law and morality, right? Law is full of principles. Some of them are expressly written like this one, others are implicit, but this is just an example of that general truth. For a positivist, though, they're going to have to say that this is an example of a gap in the law, which directs a judge to exercise discretion. So, in other words, we have an example here of something where we've tried to appeal to experiential evidence. We've got some data that you might think would count towards the truth of a theory of law. We've identified a statute, and it appears to incorporate morality. So theorists agree on all of that experiential evidence, but they still disagree about the truth. And so, again, what drives the theories here is nothing in the observable world, but rather the intuitions that the theorists sort of began with. And so this is what makes it clear that theorists who do this kind of work are engaged in a metaphysical project, and it's not a sort of sociological one. They do call it descriptive, but they mean descriptive in terms of describing the true nature of law, not describing empirical facts about law. What my concern here is that in adopting that kind of methodology, theorists have essentially made their accounts unresponsive to experience or to evidence. And so one thing that I want to distinguish here or make clear is that this question of the nature of law is independent of the question of what makes for good adjudication. So the question of the nature of law that I've just been talking about is a metaphysical one about what law is really like. But the theory of adjudication doesn't necessarily flow from the theory of the nature of law. So we could have, again, a situation where there's a great deal of agreement between agreement about adjudication between those who might disagree about the nature of law. So let's say both positivists and non-positivists might happily agree that moral factors are appropriately taken into account when judging, right? But the difference centers on how they describe what's going on when judges do that. So everyone's going to agree that judges appeal to morality, but the nature of law problem then reduces to the question of how we describe what judges are doing when they appeal to morality. So everyone agrees they do appeal to it, but one side says they're finding law, the other side says they're making law. So again, we can look to this provision that's trying to identify unlawful contracts. Everyone's going to accept the fact that a judge is going to appeal to moral reasons here, but they're going to say that there's still a further remaining question. So the question would be put like, when judges exhibit this morally engaged behavior that we all agree that they engage in, are they really finding a right answer, or are they really exercising discretion? And it's that really that's added here that suggests there's something beyond experience. So what is it that they're really doing, whatever it is we agree that we see on the ground? And that's what brings us to the impasse mentioned above. And I think it's not a temporary impasse awaiting further data points. It's a permanent impasse really because any potential data points that we wanted to bring to bear could be just explained away or explained differently by the theories in contention. And so if that's the case, we might think, well, if this dispute is irresolvable in principle, why not do away with it? And that's exactly what I argue for. So I'm just going to spend the rest of the talk talking about the more positive argument in the paper. So the first part deals with the problems in the dispute about the nature of law, and then it turns to sort of what should we do instead, and that is I argue in favor of what I call eliminativism. So I think the question of what law is, at least when it's framed as a metaphysical question, as I was just describing so far, that question is spurious and we should reject it. And that's the view that I call eliminativism. So the name, I'm not the first to use it. There are a few people who have started talking in this way, and it's also a term that's been used in other areas of philosophy for a while. So, but the idea comes from the fact that something is being eliminated here, right? So on this view, we're eliminating this kind of metaphysical understanding of the nature of law. So as I said, there are a number of other people who put forward views that might be called eliminativist, or that they have themselves called eliminativist. And in the paper, I spend some time discussing those views, but here I'm just going to focus on my own just to keep it brief. But so according to my view, right, we've seen that adopting this methodology of seeking law's nature, and in particular doing that through reliance on intuitions, generates an impasse. That nature of law questions therefore seem to be spurious, and so therefore we abandon it altogether. So we get rid of discussion of the nature of law, and then we have to ask what takes its place. So on my eliminativist view, what takes its place is potentially multiple different concepts. So in other words, we move forward by disambiguating concepts, and we accept that multiple concepts might coexist that play different roles in our thinking. And this is a kind of conceptual pluralism, which I think makes sense with respect to law, because law, this might be true of some other concepts, but I think law is a great example of it, where we kind of feel the pull of a concept of law that highlights its connections to power, yet at the same time, we also feel the pull of a concept that emphasizes kind of what is it for our institutions to function well, a concept that talks about legitimacy and the morally acceptable uses of power. So in that way, I think there's important insights in both positivism and non-positivism, and I think our ways of thinking and talking about law more casually do kind of pull us in both directions. And so I think it makes sense that sometimes we want to emphasize law's bruteness and its kind of human created character. And then at other times we want to talk about its aspirational qualities. But the metaphysical approach that I've critiqued in this paper assumes that, you know, behind these various accounts that we have, there's a single truth of the matter that hides behind all of that. And so instead of just accepting that we might have a number of concepts that coexist, the metaphysical view wants to try to determine which of those is correctly tracking the true nature of law, and sort of says, we want to find out which one is right, and then that's the one that we use. Whereas I want to suggest we can continue to use more than one concept of law. So we can just disambiguate in the following way. We can say we have law 1 and law 2, and what we do is just specify what we mean each of those to encompass, and then we stipulate what we mean it, which one we mean to be using in a particular argument. And that enables us to then go on to ask different normative questions or sociological questions. So to do that, we don't need to settle the question of whether that account that I've just given is the correct account of the nature of law. So I just say, this is what I mean to include, and then I can go on to answer the questions that I want to answer. So there are all kinds of questions that we might want to ask, and we see these questions, already in theorizing around the law. There are questions about how we might reform our laws. So we could ask whether drugs should be decriminalized, whether the current tax system is fair, etc. Those would be kind of normative questions. Then there are sort of descriptive or sociological questions about what would the effects be if we decriminalize drugs, or what are the implications of changing that tax system. And so we might need to answer questions of both these kinds, right, empirical and normative. But my point in the paper is to show that on the eliminativist view, we can easily do all of that. We can answer those questions. And to do that, we don't need an account of the nature of law. So we stipulate really just the institutional features that we're talking about. So what do we mean by law for this purpose? We mean to include decisions of courts, statutes, etc. And then we kind of establish that that's what we intend to discuss, and go on then to examine the further empirical or normative questions that we're interested in. And I think this enables people to engage with one another rather than talk past each other, because even if I'm talking to someone who doesn't agree that what I've stipulated is like the correct account of the nature of law, they can still go along with some of the questions that I'm asking by sort of saying, well, yes, we can ask about how that stipulated set of norms could be made more just or more coherent or better along whatever dimension we're concerned with. They can still engage with all of those questions without settling the question of whether I've got right the nature of law. So the idea here is that multiple concepts can coexist. We don't need to answer the question of which is correct. We simply start by stipulating. So the main that's kind of the picture that I wanted to put forward. This idea of having multiple concepts and stipulating which we need to use. And I just want to close by talking about one objection. There's a number of objections raised in the paper and discussed, but here I'm just going to focus on one, really because it's the main one that I think is present in people's minds when eliminativism is suggested. And that is the idea that when we become eliminativists, we're sort of stuck because, well, how on earth can we go on talking about law? And clearly we need to talk about what the law is. And so that seems to pose a problem. So eliminativism seems to mean giving up on making any claims about what the law is, or about what the content of the law in force is. And I think for a lot of people that seems like a very kind of counterintuitive view. So when people object to eliminativism, they often say, look, it sounds like a very attractive view. As nice as it might be to dispense with a question that seems difficult to solve, we can't possibly give up on it because the answer to it matters. So we need to know what the answer is because we need to know what the law actually demands of us. And so in the paper, I try to answer that objection. And I try to show that when we abandon the nature of law debate, as I suggest we should, we actually aren't giving up on anything that matters. So I'm going to just briefly go through that response here, and then I'll close. So if the worry is we need to know what the law is, right? We need to answer the nature of law questions so that we can answer concrete problems about what the law is. I have sort of a short answer to that and then a long answer. My short answer to this objection is really just that I think it gets things backwards, right? It can't be that we need an answer to get by because we don't have one and we do get by, right? If we were really, if eliminativism was really to cause this problem, then we should be seeing this problem already, because we have no settled answer to the nature of law. There's disagreement about it already, and yet lawyers do their jobs all the time. People are able to answer questions about what the law is. So the fact that lawyers and citizens go through life without settling the nature of law question actually should show us that having a settled answer to it is not essential. But again, that's kind of just a bit of a cheap answer. So I'm going to give my more detailed one as well. And so in doing this, I am mostly responding to Liam Murphy, who writes about eliminativism. His book, What Makes Law, has a really nice discussion of eliminativism. He ultimately doesn't endorse it, and he puts forward a number of quite forceful objections to it. So that's why I kind of use him to engage with and respond to his objections. So one of the examples he uses that I'm going to focus on is the example of same-sex marriage. So he's talking about the law in the United States, and he says whether the exclusion of same-sex couples from the institution of marriage in New York was a violation of the state constitution in, say, 1995 depends on knowing what the law is. So we need to know, right? On the positivist view, it's a matter of the social facts. And so if we look at the social sources, then Murphy says positivists will conclude the sources didn't determine this question, and it was therefore open until it was settled by a court in 2006 and then changed again by a legislature in 2011. So that's going to be one story about what the law is, right? Non-positivists, on the other hand, they're going to say that, look, the question of what the law is about the morally best reading of the legal materials, and therefore they'll conclude that it was actually always illegal to limit marriage to opposite-sex couples this whole time, regardless of the court's decision or the new enactment. And so, according to Murphy, we would say these different accounts of the nature of law lead to different practical conclusions about what the law is, and that does seem to be a puzzle for the eliminativist, right? If it's true that we get different answers to what the law is, then it does seem to matter who's right about that, and so then we can't really get away with eliminating the debate. And so my kind of way of responding to this is to question whether anything really does turn on the answer to the question. So in what sense will my experience really be different if one view or the other is right? So one thing that clearly matters is whether the officials will perform or uphold my marriage, right? But the answer to that question is going to be the same on both accounts. So there's no difference in practice to the person who wants to know whether their marriage will be upheld. And so if we think back to the conceptual pluralism framework that I kind of fleshed out earlier, there are times that we do want to know just like what is it the judge is going to do. So sometimes that predictive question of, you know, what are the people in power going to do? That might be the question we're asking. And that's not the same thing as asking what the law is. So we can get rid of that question and just say, look, sometimes we're interested in the predictive question. So will the officials uphold my marriage or not? But that's not the only question. And sometimes when we're asking what the law is, we're asking more like for an assessment of what the right answer would be, bearing in mind kind of normative questions about the legitimate use of state power. So we might be asking a different kind of question as well. But in both cases, I think we can use the conceptual pluralism to disambiguate those questions and still get to the bottom of the important questions that are at stake. So I guess a different way to come at it is that one of the points Murphy makes is that giving up on talking about what the law is or adopting an eliminativist view requires kind of a bunch of paraphrases, right? It requires us to paraphrase that question into sometimes a moral question about what the person ought to do, sometimes a descriptive question about what the state is going to do. And that's exactly what I've just done, right? I disambiguated into a variety of different questions we might be asking. And so Murphy's point is partly that this is an artificial approach and that it kind of misses something. It kind of forces us into these awkward paraphrases. But I think my response here is really just to say that these kinds of paraphrases are actually what we're already dealing with. So law is, in various instances, being used as a placeholder for a particular idea. And sometimes it's being used as a shorthand for what are the people in power going to do. But other times it's being used as a shorthand for some idea that we've committed ourselves, morally speaking, to certain standards of behavior and interaction. And we might be asking what the implications of those commitments are for what judges should do. So when people to come back to Murphy's question, when people ask questions about whether same-sex marriage is against the law, they might sometimes be asking one kind of question and sometimes the other. So sometimes they want to know what are the judges going to do, and sometimes they want to know sort of what does this whole system actually demand of us. And so, you know, I think often when we're talking about lawyers advising clients, we're probably talking about the former question, the predictive question. But sometimes we're talking about what are our moral obligations to one another as citizens. And so I think my point here is really just to say that we should be aware that there are often at least two possible questions in the vicinity. What are the people in power likely to do, and what are my moral obligations? So in my view, it's not that eliminativism requires us to make these kind of convoluted paraphrases. I think rather it reminds us to inquire further about how a term is actually being used, and to recognize that the what is law question is often hiding one of these paraphrases already, right? One of those questions might already be what's lurking in the background. So as I said, there are a number of other objections in the paper, but that's the major one that people raise, is sort of how can we talk about the law while still being eliminativists? So that's the one I wanted to really deal with in depth. Any others I'd be very happy to take questions about, but I'll leave it there and open up for your questions. So thank you very much for listening.
Thank you, Hilary. That was a very nice summary of the paper, and thank you for doing that. I invite now Ronaldo to make his comments, and then we'll open the floor to the questions to anyone else who wants to say something. Okay.
Well, thank you, Thomas. Thank you, Hilary. It was an excellent introduction for your text that presents argument in a very clear and a pedagogical way. The main arguments for and against eliminativism in legal philosophy in the current debate. It's a wonderful and thought-provoking paper. Thank you for writing it. Well, I'll not sum up the arguments, since Hilary has already offered us a very good introduction to her ideas. Even though she has already addressed many possible objections to her own view on eliminativism, I'll try to offer some extra provocations from another perspective. Well, I'll first make a kind of very general point and then go to other more specific ones. So it seems to me that eliminativism is trying to fight an absolute conception of law, an essentialist view of what the law is, usually referred as the real nature of law, as Hilary mentioned in her exposition. On this account, it seems correct to say that we don't need such a kind of concept of law, such an essentialist conception of law. In many ways, eliminativism arguments seem similar to Wittgenstein's critique of essentialism. However, why should we move from the critique of one essentialist kind of concept to a full rejection of any kind of concept of law? Why not, for example, accept that the concept of law should be understood as a family resemblance kind of concept, very much like the famous Wittgensteinian metaphor of a thread composed by many fibers that interconnect to each other? Why not? So my point here is, even if we agree with this negative dimension of eliminativism, which is the critique to this essential real nature of law kind of concept, why should we move forward and accept the full rejection of any kind of conceptualization that seems to be coming together with eliminativism? A similar account of law, I think, is presented in legal theory by Dworkin's account of the different kinds of concepts of law, especially the way he presented it in Justice in Robes and Justice for Hedgehogs. There, in these books, instead of criticizing the concept of law in general, Dworkin tries to show how different kinds of concept, natural kind, like criterial kind, a sociological kind, doctrinal kind, or interpretive kind, functions differently in different contexts of use or in different language games. So this view is also connected, I think, with another important aspect of the task of philosophy of law and philosophy in general. One of the most influential philosophical currents in philosophy of language in the beginning of the 20th century was the project known as Logicism. According to it, main leaders like Bertrand Russell or Gottlob Frege, the task of philosophy should be to obtain clear understanding of the world. In order to do that, we should avoid misunderstandings created by an imperfect, ordinary language that should be replaced by an artificial language free from inaccuracies. So the failure of the Logicist project was made evident by many philosophers, and among them later Wittgenstein, who tried to show how nothing was hidden in language. This is also the name of an excellent book by Norman Malcolm, Nothing is Hidden. The language was right the way it was. The major problem was that philosophers, the philosophical way of trying to reduce all language was simplified, essential and unique grammar of language, instead of acknowledging the existence of multiple language games in which meaning was formed. So it's worth noticing that the Logicist project was a positive one, in the sense that they tried to create an artificial language in order to solve philosophical problems. However, the first reactions against the Logicist projects were a negative example of the same philosophical mistake. What the first critiques of the Logicists tried to say was a full denial of any possibility or any usefulness of an artificial language, since no Logicist effort would lead to the abolishment of the philosophical misunderstandings and misconceptions. So my point is that both Logicist project and the first reaction against it share the same misconceptions about language. They have some kind of absolute conception of language and absolute conceptions of how the meaning of the concepts work. Eliminativism seems to share some resemblance with this attitude of denial of the Logicist project. However, instead of offering a better understanding of how different concepts work, it recommends the elimination of the concept. Or at least there is some kind of suggestion in this way. In this way, I wouldn't characterize working as a proto-eliminativist, as Kornhausen does, and you quote this in page 33, but rather as someone who acknowledged the negative, correct dimension of the critique of the essentialist conception of law, about law's nature, this metaphysical view of the law's nature, but at the same time tries to show that there are what are the possible kinds of concepts, what are the possible different language games that create different meanings for law, the concept of law. So this is my general point. My second one is this. Well, but what is the usefulness of the concept of law, or the concepts in plural of law? Well, first of all, it depends on which kind of concept we are talking about. To use Dworkin's conceptography, if I may call it so, a criterial concept, an interpretive concept, a doctrinal one. I'd like to put my arguments in the classical example used by Dworkin in Law's Empire. He mentions there the famous TVA case about the construction of a dam in the Tennessee Valley. There, in this case, Justice Berger and Justice Paulo agreed on all their responsibilities towards the law, their legal obligation to follow the law. They also agreed on the empirical data of the case, the existence of a protected species called snail darter, the validity of the Endangered Species Act that protects the little fish because of the dam, etc. They disagreed on the grounds of law. In other words, they disagreed on how to conceptualize the very concept of law. isn't this case a good example of the relevance and usefulness of the discussion about the boundaries and about the kinds of concepts of law there are at stake? I mean, isn't it a good case in which what is in disagreement is the very way by which the two justices conceptualize the very concept of law? I have a very I'd like also to mention and go back to the example of the same-sex marriage that you mentioned in Murphy's argument in page 41 and following. My question here is this: doesn't all this disagreement, all this polemic about same-sex marriage depend on the concept of marriage that is at stake? For example, if I take Scott Shapiro's argument presented in his book Legality about how to understand this question, according to him, marriage is a concept that should be understood in a conventionalist way. That means marriage is a kind of heterosexual kind of family that is created when two people of different sex decide to live together. So according to him, this is what we should understand by the very concept of marriage. However, when the issue about the existence of a right of same-sex marriage is being discussed in the courts, what is at stake is basically what is the nature, what is the kind of concept is marriage from a legal perspective. I mean, what is at stake there and is exactly how should we understand the legal conceptualization of marriage? Should we understand it as a also moral or partially moral concept or not? Or should we conceptualize it as a conventionalist way, as it is recommended by, for example, Scott Shapiro? So when I take this example, I come back with some doubts about the uselessness of the concept. It seems that not all legal disagreements, at least some legal disagreements in hard cases, are directly connected about disagreements on how to conceptualize this concept. I mean, it's a disagreement about the kind of concept of law that is at stake in that situation, according to Dworkin's language. Is it a doctrinal conceptual concept? It's an interpretive concept of marriage, or whatever. So when I take the same example, it seems that it proves the usefulness of the debate about different kinds of concept of law, instead of proving the possibility of simply eliminating it. And just a final question is that you often mention the idea of different theories of law would be based on mere intuitions. And you mentioned that this is a very controversial concept. But my question here is, why not conceive them, these concepts, as based on a shared concept of something? That means some kind of conventional understanding of some kind of shared understanding and shared practice, and also some disputes about the best way to conceptualize or to reconstruct this very concept, much in a way, much in a Dworkinian way or interpretive way of approaching the question. Why do you put so much stress on this idea of the concept is always merely departing from intuitions? That's my question. So thank you very much again, and it's really a very thought-provoking, well-written paper. Thank you, Hilary.
Thank you very much, Ronaldo, for the great comments, and I think that this gives Hilary a lot to think about. So just before opening up for further questions, I will just pass the word to Hilary. So she can give us a short answer, a short reply to you. And those of you who want to make questions, just raise your hand or just write me on the inbox and I will hand it over to you, okay? Hilary, thanks.
Wonderful. Thank you so much, Ronaldo. I really appreciate those comments. And as Thomas said, it's given me a lot to think about. So I won't be able probably to give a satisfying response to all of it just now, but I'll just give you kind of my thoughts on first hearing these thoughts. So the big, large question about kind of what is eliminativism doing, and is it sort of fighting against an essentialist vision of what law is that's maybe not the entire vision of what everyone sees law to be, and further whether it could sort of understood as, or in other words, whether we should go towards a more kind of Wittgensteinian kind of way rather than eliminating things altogether. I guess my answer would sort of be yes, I agree in a way that the kind of that there's a lot of truth in the sort of the Wittgensteinian kind of reconstruction of things, but I don't see that as necessarily in tension with the project that I'm doing. So it depends on whether you are suggesting that we should, so when you talk about it being a family resemblance concept, I'm perfectly fine with that being sort of one of the ways that we talk about law. We might sort of conceptualize it that way, and that might be helpful. What I would sort of, where I might run up into disagreement would be if you were to say, the family resemblance concept is really what it is, what it always is, and what it always has been, and there's no alternative picture. So, because once you start saying that, then you're sort of also moving into more essentialist kind of territory, which I think we both agree to move away from. And so, if that's the case, then I think the main point that I would want to make is that we should stay on kind of conceptual pluralist territory. So even if we want to understand our concepts as family resemblance concepts, we still don't want to be saying, and once we analyze it that way, we're able to see that positivism is true or vice versa, right? It should be a tool to help us flesh out those various concepts. But what I'm really more deeply opposed to is the idea that through any of these methods, we could then say one concept is the actual true concept. But I think Wittgenstein would be on the same page with that, unless I misread him. And so I guess in general, I took your point to be that, look, we're objecting to an essentialist picture of law, but like not everyone takes that kind of view. I think that's probably true, but I do take my target to be the many people who I think are arguing for a kind of essentialist picture. So anyone who's already on board with kind of family resemblance kind of picture or an anti-essentialist view of law, I think would probably be already friendly to the kind of view I put forward. But I guess, so I'm not sure if this is the part that I sort of maybe think I need to think more about in what you said, kind of the move from that to suggesting that maybe Dworkin's not a proto-eliminativist, because I do feel quite convinced that he is. And so I wasn't sure if there's something I'm missing in the move from the earlier discussion about anti-essentialism. So I think it's true that Dworkin critiqued essentialism, and then as you said, he tries to put forward multiple concepts with different meanings, but I think all of that's completely compatible with what I'm saying. So I don't know if, I know we want to leave time for other people to come in, but if you wanted to come back in on that point, I'd love to hear more about sort of like that connection, or why you think that Dworkin isn't best understood as an eliminativist. And I'll just say briefly on the last couple points that you made. So on just briefly on the intuition point at the end, I think the main reason, so you asked partly why I'm so focused on intuition. I mean, really, the short answer to that is just that I'm following the literature, and people like Raz talk about intuitions as the sort of, and Shapiro too, as kind of the raw material for doing conceptual analysis, right? And so that's sort of what I focus on because of what others are doing. But I think, so you talked about the idea of a shared conventional practice instead. Yeah, to the extent that people are doing that, then I think that's a perfectly plausible way to go, except for the worry that it's not necessarily shared. So I think the problem part of my reason for emphasizing intuitions is that they actually aren't often shared. And so, yes, to the extent people manage to put together a shared concept of a conventional kind of picture of law and they move forward with it, then I think they're just kind of doing what I'm suggesting we should be doing. But my problem is many people like Raz and Shapiro are not doing that, and they are relying on intuitions, which is my reason for focusing on those. And just finally, yeah, the point about doesn't it depend on the concept of marriage at stake? So I'm not sure if I fully got the problem here, but I think what you were saying was that in some sense there's kind of eliminativism about law, but then once we get into our analysis, we're using other concepts as well. And should we be eliminativists about those concepts as well, or how much does it unravel, right? And if we're using kind of a conventionalist account of marriage within our account of law, then do we need to be eliminativists about that? So I guess my answer would be sort of yes, we might be eliminativists quite far down. I don't think there's necessarily a true answer about what marriage really is. I think the important questions are all normative ones. And so it might be true that we have a conventionalist understanding of marriage, but just as I think that we can stipulate, so just as I was saying, we can stipulate ideas about law to then move forward with other questions, I think we can't unravel everything all at once. So what I would suggest is we stipulate for this purpose, we mean marriage in the sense of however it's defined in the statute, as you were saying, a kind of conventionalist picture, because that's what we're concerned with for the purpose of knowing, like, are people going to get the result that they want? You know, is the government going to uphold the marriage? So we stipulate we mean marriage in the government's sense, while sort of bracketing and saying, well, this might not really be the correct account of marriage, but that's the one we're going to use for now. And then stepping outside of that dispute, we could have a whole separate dispute over here about like what the right account of marriage would be, morally speaking, in the sense of, you know, what ought we to owe to our fellow citizens, right? When we're trying to design a system that would be fair and inclusive and egalitarian, right? So I think that I'm eliminativist about a lot of concepts beyond law, but that when we're using them within law, I think there's scope to be more or less eliminativist, depending on kind of how easy it is to just stipulate a concept for our usage. But yeah, thank you so much. That's given me a lot to think about.
Thank you, Hilary. I would have my own questions. I reduced it to 4, but I don't want to be an unfriendly host. I want to be a good host. So I would invite others to make their questions before. In the beginning, David mentioned something. Would you like to come in, David, to ask anything?
Sure, thanks. Hilary, it's really excellent work, and we've had some opportunity to discuss it in the past, and I think it's really developed even from those earlier discussions. So a couple of quick things. The first is, I still wonder whether the eliminativism throws us off, because it suggests you want to eliminate the concept of law, but in fact you want a plurality of concepts of law. What you want to eliminate is this fixation on identifying what the law is, right? I wonder what you would say. I'll pick up on the Dworkinian vein, but maybe also actually going back to Finis. So I wonder what you would say to someone who says, look, the basic or primary concept of law is the practical concept. That is the concept that we use within a practice. And let's suppose we give that the Dworkinian spin, right, at the practice of identifying those rights that are enforceable upon demand without any further action by the political community. So that's the basic concept. And then we go in the pragmatist direction of saying practice is primary, semantics comes later. That is, the description of what we're doing comes later. And the positivist concept of law comes later, right? It is this kind of partial description of what we know when we are competent practitioners of law. So we can talk about multiple concepts, but really we've got one concept which is kind of derivative from the more basic concept. And in fact, you know, roughly, Dworkin is right. We can tell a story about exactly what mistake the positivists have made, and there's no need to eliminate the concept of law.
Hillary, to you, I'm just noticing, taking a note of the people who want to make questions. Sorry.
Yes. Shall I go ahead and answer? Or
No, just answer him, and if many questions pile up, we can answer in blocks. But for now, it's fine. Yeah.
Perfect. So yes, on the first point, I completely agree, and it's something I'm a little stuck on. So you know the other paper that I've written, which was trying to kind of categorize a number of views that have been called eliminativist, but that really are doing different things. And some of them are more truly eliminativist in the sense that it's used in say, ontology in philosophy, where we're actually saying we're eliminating this entity, but that's a metaphysically committed view. And you're right, that's not what I want to adopt. I think the language is what it is, partly because this is just the way it's started to be talked about in legal philosophy. And so it's sometimes hard to fight the tides. But yeah, it is in some sense a misnomer because I'm not eliminating some entity. I'm eliminating, as you say, kind of a question or a fixation or a way of thinking about things. I guess what I eliminate is any kind of claim that there's a singular nature to law, but I'm not claiming that something doesn't exist, which would be strictly eliminativist. So I don't know. I think the unsatisfying short answer to that is that I'm just sort of using this language because it's how people have already started talking about it. But I think you're right that my main point is to say that, look, we don't want to eliminate, rather we want actually to multiply concepts. We want to have many. And I guess that kind of goes to your second question, which is you were sort of suggesting one concept is primary. And I think I want to really push back on that because that still seems to me to rest on an idea that below that concept, there's something that's more fundamental or more true. And I think that opens the door to continuing the debate about what the nature of law truly is. If you're saying one concept's primary because it's kind of closest to this true nature, and then others might be secondary or derivative. I resist that because I really want to make it clear that my goal is to say, look, none of these have any kind of link to the nature of the universe or what law is really like. They're just frameworks that we as human beings employ to understand our environment. And sometimes this framework is useful and other times a different one is. So I would kind of resist putting any one of them primary. But if I may have missed the argument for why we would want to go that way. So feel free to jump back in and clarify that. Like, am I losing something by sticking to that?
So just real quick, because I know there are other questions. I'm not sure that you're losing something, but somebody might make this kind of argument to basically say, I can explain why there are a number of concepts that are being used in various discourses, but I can do so in a way that gives a kind of priority to one of those. Mm-hmm. The other is, if you think that the concept of law is a practical concept, then you're not committed to it being true in a representational manner, that is, being true because it somehow corresponds to a practice-independent reality. So if you have that kind of metaphysical worry, you don't necessarily need to have that concern.
Yeah, that's helpful. And I think because I do have a kind of pragmatist instinct, that is appealing to me, but I'm still wanting to resist the idea of saying that that's in some way primary, only because I don't want to open the door to further, like, to entering back into that debate. But yeah, the idea that, if there's a way to explain the multiple concepts that does give one priority, I think I'll have to give more thought to that and see if there's an answer to that.
Hillary, I think that David just anticipated a point that I would like to make, because when I read your paper on working in pragmatism a few years ago in the Canadian Journal of Law and Jurisprudence, you mentioned that you read him as a pragmatist. He could be understood as a pragmatist in Peirce's sense. And when I read the paper that you presented today, you start with the assumption of the primacy of theory. So you start all the non-eliminativists, the people who are discussing the nature of law, they start with the idea of a primacy of theory, of philosophy, and then you explain reality. You start with your intuitions and you try to explain these intuitions. But why not start with the priority of the practices? And like David suggests, and perhaps we can see other things, because for the participants of the practice, I think that it would be very difficult to accept an elimination of the concept of law. And that's one of the points that I would like to raise. My question is whether or not you are retaining the assumptions, the implausible assumptions that led people to trust on their intuitions to postulate an essentialist conception of law. So that was just my point. I don't know if you want to react to this or whether we should collect other questions first. Yeah.
Yeah, I do want to get lots of questions, so I'll just very briefly say I think that's a really interesting suggestion, and I do think starting with practice is important. I think my kind of quick answer to that is kind of along lines I mentioned in the talk. I think starting with our practices actually pulls us in two directions right away. So even if we start from practices rather than intuitions, I think we're going to end up in a conceptually pluralist kind of space rather than sort of being, I think we'll still be driven away from settling the question of whether law is necessarily one way. So that I think would be my answer, but I'll have to give more thought to it as well.
Yeah, okay. I would have a follow-up too, because I would say that you can't settle questions like justice, what is justice, or what is freedom, or what is the good, but we operate with these concepts all the time. And sometimes you claim that in the very last sentence of your paper, you said that if we drop the question of the nature of law, we would still have truth-apt questions about how judges should decide cases. So in the end of the day, I think that what we should drop is the essentialism and the metaphysical methodology that dominates the scenery of legal philosophy. But you only want to eliminate the question, what is law, because you understand the question in the same way, because you retain the metaphysical assumption or the idea that it is a metaphysical question. If you drop this question, we have no problem with the concept. If we drop this method and adopt a synechist methodology for law, for instance, like Gerald Postuma holds, you no longer need to drop the questions, and you can have all the benefits of having a concept of law, a doctrinal concept of law. Which I think another question, sorry, I jumped in front of everyone and asked what I wanted, because I think that a doctrinal concept of law is not a metaphysical concept. In the way that Dworkin defines it, a doctrinal concept is a political concept. It's the concept we apply when we want to know what our rights and duty in a community are. I mean, there comes a debate, and I want to know whether or not I have the right to marry someone, and someone else says no. And so let's turn to the concept of law to see if it can help us. So this is a practical concept, a pragmatic concept, and this is what Dworkin means by a doctrinal concept of law. So it cannot be a metaphysical concept in the sense that you take the priority of intuitions or priority of conceptual questions. It should be the other way around. And I think that I'm done with the question. So I would like to hear, maybe we can listen to 2 or 3 questions and then you answer, because I already have 3 people in the queue. Could we do that?
Yeah.
Okay, let's start with, I don't know how to pronounce your name, is Zhang?
Hi, thanks, Thomas, and thanks, Hilary. So my question concerns your commitment to the obligation to obey the law. I'm not so sure whether I'm misstating the paper or misunderstood it otherwise. So we know that traditionally the concept of law is linked with the question of the obligation to law, or even arguably the political legitimacy. So given the eliminatist view that you are going for, so can I understand you are also committed to the view that there's not a categorical obligation to obey the law? So, for example, in one of the latest paper by Professor Kornhauser last semester, I understand you may also participate in the NYU colloquium. So, by virtue of the achievement concept of law, he puts forward this question: the obligation to obey the law might be contingent to the value, as he argued, that to which extent such a mode of governance has been realized. So back to your paper, I'm not so sure whether you are interested in the further explorations along this vein, that how would your general view about the obligation to the law given the eliminist point of view? Thank you.
Hilary, I turn to you now. I already got the two questions and I will call them later.
Okay, wonderful. So I thank you for that question. I think, I guess what I would say is, yes, I do think that there's no categorical obligation to obey the law. And that really stems from the conceptual pluralism that I adopt. So basically, it's not that I think that's an unimportant question. I think it's an all-important question, but I think it's a question that can only be asked once we establish what we're talking about. So I would suggest that we sort of first say, understanding the law as, this positivist concept, then is there an obligation to obey? And we would then be able to answer that question one way. And then we might say sort of understanding it as a kind of more morally rich kind of concept, stipulating that concept, we then go to say, well, would that generate an obligation? Maybe yes, maybe no. But I don't think we could ever answer the question of whether just law per se gives us that obligation, because there's still too much ambiguity about what that is. So yeah, I would think part of the advantage of my view is that by stipulating in the first place what we mean by something, we can then open the door to better answering those other questions. Thanks.
Thanks, Hilary. I invite now Daniel Murata for his question.
Hi, hello, everyone. Thanks, Hilary, for the paper. That was super, super interesting. And in general, I'm really, really sympathetic to your arguments. And I think, for instance, it has an important advantage when you compare with Hershowitz's proposal, because whereas Hershowitz's proposal boils everything down to morality, you are not really committed to that. So I think that the paper is really, really, really insightful. So what I had in mind, I'm not sure if it's a helpful criticism, a commentary, or a question. So what I had in mind was the following thing. Can't we talk about some sort of token concept of the law? What I have in mind is the following thing. One of the senses in which we use the concept of law is as a sort of expression, the law is a sort of expression of a community's moral political judgment. So when you think about what you're saying on section 10, item C and D about the expressivist role of the law and the internal point of view. So regarding C, about the expression, the law as an expression of something, you give the example of a gay citizen in Singapore. So the object of his complaint in C, thing C, could be, I think, the expression of the judgment. So what the citizen is actually complaining against when he's saying complain against the law in Singapore, he's actually complaining against the law as an expression of a political and moral judgment of that community to which he belongs. So that, and in the same vein, when we talk about in D about the point of internal point of view, the acceptance of internal point of view can mean acceptance of that expression of judgment of a community. That's why I was wondering if law could work as a sort of a token concept. And the thing is that this is not the same thing as claiming that the person is either complaining or endorsing the moral requirements of the practice, nor the same thing as a stance regarding what officials are likely to do. So it seems that there is a sort of layer that the paper is not tackling, the paper is overlooking, a layer in which you can have different attitudes of the citizens, first-person attitudes of the citizens, the legal subjects, regarding the law. And here I have in mind things like Joseph Rass's work on respect for the law, or John Dee's work on the authority of law, and when you have those sort of personal attitudes towards the law, you need to have some sort of concept that those people are articulating, they're actually referring to. And what I'm not sure about is how can eliminativism explain that concept. So I'm not really sure if this is a criticism or a sort of suggestion to your argument. It's basically the idea that there might be attitudes of the subjects towards the law, and these require some sort of concept to which attitude is directed. So that's basically it. Yeah.
Yeah, that's really, really great. Thank you so much for the comments as well. And I guess, so I'm not sure if I'm fully getting it, but let me try this response and see if it works. So I guess what I would say is, it's true that people often do have these different attitudes, as you said, of acceptance or even of criticism, various attitudes towards whatever they take the law to be, right?
Yeah.
But it still seems to me, so it seems to me that what we would need there is some kind of, I don't know, survey or something to determine what it is that they believe themselves to be committed to. But I think what we don't need would be an account of the nature of law, because it seems really implausible to me that what any of those people are thinking is, look, once I figure out if Raz or Dworkin is right, then, you know, whichever of those views is right, then only the law that's picked out by that account is what I intend to follow. I don't think that's the internal point of view. It seems to me that it's got to be something else. So I don't know what necessarily what all of those people are committed to, or whether they even have a coherent viewpoint when they do see themselves as, in some vague sense, committed to law. But I would guess that we could figure it out not through answering the nature of law question. Does that make sense?
Yeah, I think, yeah, that was what I was thinking about. I think, yeah, I mean, the fact that people have attitudes towards the law does not mean at all that they're committed to some sort of nature of the law. So I think, yeah, but then you need some sort of concept. That's what I was talking about, a sort of a token concept to which they can refer to. And that's the kind of thing that I don't think you can eliminate.
Yeah, can you just say a little more about what you mean by token concept?
Yeah, actually, I'm using like in a really loose way. I was just thinking,
Yeah.
they need to refer to something, because the attitude, they have an object. So
Yeah.
now, how are we going to understand that object? That's another matter altogether. So someone can have, we can have something almost like a Kafkanian view on the law, in which you simply don't know what the law is, but you know that the law is there, and that you and so and that's the kind of thing that we can't actually eliminate.
Yeah, that's interesting. I mean, I think I'm inclined to say that probably they have like either a confused or simplistic understanding, but that whatever it is, we could stipulate, yes, okay, we mean that stuff, whatever stuff you're,
Yeah.
I don't mean to say that everyone's views with the law are confused, but given that even lawyers disagree about this, I highly doubt that like lay people have a clear view of what they think they're deferring to if they defer to law. But if we, I mean, you're right that there needs to be something there, but I think that something could actually still be a very confused something. So trying to settle or clarify the concept of law won't necessarily do the work of filling in what it is those people happen to believe. Thanks.
Thanks, Hilary. I invite now Thiago Deca. Deca, are you there?
Okay. First of all, I'd like to thank Professor Nye for the talk. I thought it very interesting and very thought-provoking. Unfortunately, I couldn't read all the paper, but I started and read until page 20-something. And from the exposition, I think I got the main idea. And so I have only one question. I was under the impression that the problem with the concept of law, as it's been understood by the analytical jurisprudence tradition, is the fact that first of all, it is quite essentialist, as Ronaldo put it, and you recognize it's a problem for your understanding of what's relevant in understanding law. But there is other assumption. I think David also mentioned it, that it is a kind of representationalist dimension of the way of understanding what are concepts and how concepts work. The idea that has got to be something under or beneath the concept, which is central and to which all of its use is referred. But when you think of it, this kind of commitments in understanding how concepts work, they form only one way of thinking about what a concept is, how to understand concepts, how they function, how they get their determinate content. And I was thinking if the critical part of your paper wouldn't allow for a way out that is not eliminating one concept of law, but understanding the concept of concept that you would further apply to law in a non-essentialist and non-representationalist manner. That is, instead of understanding that we fix the meaning of a concept or of a linguistic expression by some method that doesn't include its use, and then it determines how we use the concept later on, we could try to develop the concept of law that adheres to a conception of a concept of concepts that understand the relation between content and use the other way around. Concepts get their content from the way they are used. And in this way, if there is an available theory that would explain in a systematic way how the use of concepts in their variety of possibilities can confer content on a concept, then perhaps we could get another way of understanding concepts that understands that concepts are never completely determinate and never completely indeterminate, and that people could get concepts at different levels of complexity, and this would also account for the disagreements regarding the content of the concept, of the concepts in general and of the concept of law. I'm saying all of this because there is already available a theory of concepts that has this global structure, which is Robert Brandon's conception of how concepts get their content. And in this way, would you be open to understand your eliminativism as rejection only of representational essentialist concept of concepts, and would allow a concept of law that would be inferential, open, whose content could evolve and would be sensible to the different kinds of employments and applications. Yeah? I don't know if I'm clear, but I see a very interesting way forward in this kind of theory of concepts and theory of linguistic meaning, as we see in Robert Brandon inferentialism and his pragmatism. But anyway, I hope I was at least a bit clear of about what I want to know, and thank you again for your brilliant presentation.
Thank you so much. Yeah, that was very clear. And I think I won't say much because I think I do agree with pretty much everything you said. There's sort of two things going on in terms of what I disagree with. And the first one is exactly what you said, the representational nature of concepts, that the kind of move that people like Raz make that say, when we understand a concept, that will tell us something about the nature. That's the move that I object to. And I think that's the problem. The other thing I object to is kind of which is connected to that, right? But any claim that the concept is actually telling us something about the nature means it's the only concept. And so that's where I get to the pluralism point. So I think I definitely agree on the representational view. I don't know whether the view that you're talking about, I have to look at the branding stuff. So thank you for that reference, because I think, you know, I'm very on board with his kind of pragmatist way of thinking. So I think that would be a great way to go. The only question I have would be whether it's still trying to make a claim about being the singular concept of the thing, because I think I would still want to keep open the door to multiple concepts. But at least the way you described it, it sounds to me it would be very much open to that pluralism.
Okay, thank you very much, Hillary. So there's no person in the queue now, and we only get 10 or actually 13 minutes. Would you like to come back to the question that I made you in the end about working? Do you think you changed your mind, whether he was a pragmatism or now a proto-eliminativist?
Yeah, so I definitely, I want to come back to your questions, and it seemed to me that there were two in there. There was the can't settle what's good and what's just question, and then can you just sort of rephrase the first one?
Let me just rephrase everything. The first question is that perhaps the criticism against eliminativism is only sound if you retain the methodology of conceptual analysis. In the same spirit of David and Tiago now, I would say that if you put the priority in the practice and you assume in a pragmatist way that theories should track practices, should be accountable to practices, and should make sense to participants of the practice, then a non-eliminativist account would have a better chance, because the participants of the practice would tend to accept that they are talking about something that exists when they are talking about the law. So this is one question. And the other is about actually three questions, about the doctrinal concept of law, because I interpreted the doctrinal concept of law when Dworkin defines it as a practical concept, a political concept, that we only refer to it when we want to know what our rights and duties are. So when we want to know what we are entitled to, we turn to the concept of law. So in this sense, I think that this interpretation is different from what Louis Kornhauser says when he reads the doctrinal concept of law. And perhaps is an interpretation that would make eliminativism more worrying. And the last question was about other concepts that we just can't eliminate, like justice, the good, the right. And we go about arguing about them, even though they are disputable. And what if law is one of these concepts? So these were the questions. I hope they were clear. I'm sorry.
So I'm going to give it a go, and you can tell me if I misunderstood something. So on the first one about like starting with the priority of the practices instead of the intuitions, and the idea that the problem here is the conceptual analysis, I guess my worry is that you end up reproducing the same problem, because it seems to me that if you talk about practices, we still don't have, I think, any kind of shared agreement on like what the practices are. And so we're still going to end up having to say, either we go my route and we stipulate, I mean these practices, and then we can go on in the way that I understand to be eliminativist, and we just talk about this stuff. Or if we're going to be fighting about what the correct lines are to draw around the practices, and we're saying these ones really count as law and these don't, then I think we're stuck back in the debate that I want to avoid. So it depends on, I think, maybe what you mean by the priority of practices, but I worry it would lead to the same problem as a priority of intuitions. Just on the doctrinal concept of law, so you were saying we use it as a practical concept, and we use it to figure out what we're entitled to. I guess I would want to know who's the we in that sentence, actually, because I think when Dworkin's talking about it, he is saying judges use it to figure out what they ought to do. I'm not sure that citizens necessarily turn to the doctrinal concept when they're trying to figure out what they're entitled to. They sometimes are trying to figure out what are they going to get, not what they're entitled to, but just what's a judge likely to do for them. And then they'd be employing a kind of realist, pragmatic kind of concept. Other times they might be trying to figure out what they think they're entitled to, but I kind of doubt they're using the doctrinal concept. I think they're probably using some kind of moral sense of entitlement there in determining what they think the community actually owes them. And so I think probably even the doctrinal concept is still kind of a technical idea. And what I want to leave room for is that there are lots of other concepts that might be employed among different people, whether it's judges, citizens, lawmakers, who might be appealing to moralized concepts or, as you say, political concepts, but that might have different contours. So I don't know if that answers the question, but yeah, then on the third point, I guess that's kind of one of the big questions that I've been grappling with on this. A lot of people sort of say, well, if you eliminate law, why do you say at the end that we can just sort of still carry on with all of these normative questions? Because of course we have just as much disagreement about morality, which I don't dispute we have that disagreement. I think my answer here is to say intuitions about what we ought to do strike me as the kind of thing that are appropriate for settling moral questions, whereas intuitions that we have about the world outside of us don't necessarily seem to me to be appropriate for, you know, why would our intuition about the way the world is have any kind of access to some truth about the nature of the world? Whereas being sort of human beings, we are all capable of suffering, we are all capable of experiencing pain and empathizing with those who do. And I think just by virtue of having that experience of being human, we actually are able to have intuitions that might point us in the direction of truth about morality, or at least it seems somewhat more plausible in the context of something like morality than something like the nature of the universe, right? It seems clear when we talk about like science that we think intuitions about, you know, what is this element made of are not going to be, why would my intuition have any force around what this thing is? But when people talk about the nature of law, I mean, they claim to be talking about what this thing is. So I don't think our intuitions are appropriate there in the same way that I think they are when we're talking about how to live together, how to treat one another.
Thank you for the answer. I think I really enjoyed this part. You didn't leave me without an answer. I think. Thank you. If there are no further questions, I would like just to make an announcement about the next seminars in the series. We are still receiving suggestions for the second semester, but we already have a program for the next 4 months. I will just show you in the screen, okay? So you can see the next seminars, okay? So David is the next. He's going to present a paper about pragmatism and associative political obligation. I'm going to post it next week, okay? I'm going to post this paper. We have Veronica now, the backward-looking puzzle of responsibility and negligence, some preliminary thoughts for understanding inadvertent actions on March 3rd. We have Mark Greenberg on the 25th of March, paper titled To Be Announced. We have Kevin Taw on April the 5th. We have Charles Barson. This is the paper for the book I'm editing with Margaret on fish, to work in debate. So he already delivered his chapter. It's a Clash of Titans, Hercules versus Dennis Martinez on April 23rd. And we finalized with Alan Harel, A Standing Conception of Law, on the May 3rd. We resume in August, and we are still receiving suggestions for further seminars. Thank you very much. And I will just hand it over to Hillary so she can say the last word. She can have the last words on this.
That looks like an amazing lineup of people, so I look forward to attending as many of those as I can. And again, thank you for inviting me. This has been really wonderful, and thank you all for your fantastic questions. I'll be thinking a lot about this as I work on the paper, so thanks.
Thank you, Hillary. See you all. Thank you, and David, I'm very looking forward to see you in the next. Thanks for coming.
Thank you.
Thanks.
Okay, bye-bye.
Bye.
Let's finish the recording and the transmission.